Hey landlords, this is Eric here with the RentPrep for Landlords podcast. And if you could see me right now, there'd be a little yoke on my face. That's because I did a little boo-boo on the last podcast. So we had a great guest in the office, actually had two great guests. We had Andrew Schultz, who's been on the podcast before, a property manager, and also Jaime, who is an attorney and specializes in emotional support animals. I mean, she's so knowledgeable on this topic, and Steve's going to introduce her here in a little bit. But the reason I kind of had a little boo-boo is I tried recording a video at the same time I was recording a podcast on the computer, and it ended up leading to a little bit of distortion on the audio. Really couldn't use that audio. So what we ended up doing was we hired out a sound engineer. He remastered the audio from a Facebook Live video that we did. So the audio quality that you're hearing coming up is not going to be the same what you're used to, but I just want to give you a heads up because the content is so good. The stuff that Jaime has to say on this subject, I mean, write it down, use it. She's so helpful. If you visit our site in the future, we're going to be having more information on this topic, and we're going to be working with her, hopefully, to give you more resources that you can use to protect yourself as a landlord. But I'm going to be tossing it over to Steve. I'm going to drop off this episode. Just wanted to give you the heads up. But thank you for listening. There's so much great content coming up. You're really going to appreciate it, I'm sure. So take it away, Steve.
1, 2, 3, 4, yeah.
Welcome to the Rent Prep for Landlords podcast. And now your hosts, Stephen White and Eric Worrell.
Oh, yeah. Oh, yeah. Ooh,
Thank you, Eric. So, sort of becoming our resident guest, we've got Andrew Schultz in here today, who is a property manager in the Western New York area, manages about 100 doors.
A little over, about 120.
All right. Didn't mean to shortchange you there, Andrew. So about 120 doors, but certainly our resident expert in managing properties. So say hello, Andrew.
How you doing, everybody? Glad to be here.
We're also super excited to have a guest that we've never had in here before, Jaime Michelle Cain, who's an attorney from Boylan Code. And Jaime represents property management companies or property managers and specializing in fair housing. And to landlords out there listening, she is basically going to be like Supergirl today. I feel like she is. I don't mean to, not to give you such high expectations here, but just in talking with her before we jumped on live, I mean, she really does have the answers that we're looking for as landlords trying to navigate the super complicated world of emotional support animals. So welcome to the show, Jaime.
Thank you, and thank you for having me.
So we have a couple of things that we're trying to pull together here for Jaime. We've got a couple of questions from our Facebook group that we're going to have Jaime field. But first, Jaime, give us a little bit of background about what you do, what you specialize in, and some of your experience.
Sure. So I pretty much have covered the gamut of New York State. I grew up on Long Island. I went to Syracuse for undergrad and law school, and I live in Buffalo, work in Rochester. I'm a full-time real estate attorney, do soup to nuts, everything from closings to lending. But my craft specialty is in representation of property management groups. My niche is in fair housing consulting and training, and making sure that leases are compliant, evictions, and anything that a tenant would do for, to cause the landlord a lawsuit, we defend those. So, I hopefully can answer all questions on this. This is definitely the hottest topic I've seen in the fair housing world in probably the last year and a half.
Yeah. So what do you think? What's the reason behind that? Why all of a sudden emotional support animals just come out of the woodwork seemingly? Mm-hmm. Everyone's got them. Every tenant's trying to get them. And it's a nightmare for landlords to try to navigate.
So as everyone's aware, the Fair Housing Act is a federal law. What happens is that from time to time, we'll get HUD guidance that's issued. And in 2013, there was HUD guidance issued on this issue of emotional support animals. And I feel like that was the basis for what happened and why people are now getting wind of it and using it as a resource potentially to get themselves out of paying monthly pet deposit fees or pet deposits in general.
Or, getting around
breed restrictions.
Right, or like no pet policies.
Absolutely.
All kinds of stuff. And it's definitely ramped up. I mean, we see it, start to come in a little bit, or we're hearing about it. I think a couple of years ago we did like some content on it, and all of a sudden it just exploded. It got huge. And part of it, I guess, is probably word of mouth between tenants, right? Like,
it's word of mouth between tenants. It's visual. It's seeing, if you have a no pet policy and all of a sudden you see an animal on the property, people are going to ask why and how they get that. It's when you have a pet policy and you have either a breed restriction or a size restriction, having animals on property that are not within those parameters. And what one tenant wants, as we know, all tenants want. And they all think that they're getting the short end of the stick. And so they complain.
I've even seen a lot of people giving other people tips on Facebook of how to get around the restrictions and things like that to sneak their pets in through whatever crack in the door they can find. So it's a huge issue in today's marketplace.
And let's be honest, I'll go through shortly some of the examples of what I call gimmicks, but those gimmicks started because of that. People were talking and companies started based on that feedback of how do we get around this? And now you can basically type online that you want an emotional support animal for purposes of fair housing or purposes of the FAA and try and get these licenses or documents to show the animal is classified as an emotional support animal to get around paying fees or having them be put on the airline.
Mm-hmm.
Yeah. And, you told us a really interesting story before we jumped on live, which was, I guess, the first instance of an airline saying no.
Yes.
Right?
So, personal story. My family had a person who tried to get around this, and it's not blood related, so I take no responsibility for her actions. But she tried to get on an airplane saying that it was an emotional support animal. She had one of those gimmick cards that you get off the internet saying it was classified like that. The animal flew down with its own seat on the airline. And on the way back, although they had the card saying it was an emotional support animal, because she wasn't carrying the doctor's note saying it was an emotional support animal, the airline removed her with an air marshal. I don't know if I told you that, but it was an air marshal actually removed her and the animal off the plane because the person sitting next to her said they had an allergy and she didn't have the proper documentation. So that was interesting to me.
Very interesting. And, I think there's probably some landlords out there like, woohoo, yeah, victory, small victory, one at a time. But let's talk a little bit about that because, Eric and I have talked about it in the past, and we're actually working on a project right now where we originally started trying to get a pet rock certified just to show the ridiculousness, the audacity of these companies that are willing to just accept somebody's online application and then they're going to certify them and say that, this person has a medical necessity when they really have they're not equipped whatsoever to make that determination via email, right? So we went from pet rock to llama. We started exploring a bunch of different things. But really what we're trying to do is we're trying to just expose the craziness of the fact that you can go online, pay an online certification, and have this thing sent to you. So give us a little bit of background on what these companies do, why they exist, and how legitimate are they?
Sure. So two that I pulled out, everybody can kind of Google them. They're emotionalpetsupport.com and then there's certipet.com. And basically it's a questionnaire service, which in 10 minutes will size up whether or not you have a mental disability, honestly, because they're not going to be able to tell you have a physical. They ask such questions like, how many times a week do you feel depressed? Are you under stress? Are you pessimistic about your future? Are you worrying? And after you hit yes to all those questions, then basically you get qualified to be considered somebody who is disabled. The doctor's never met you. You've never spoken to the doctor individually. They have no other prior medical diagnosis for you, no family history, nothing like that. At the end of it, you get a card that says, okay, I'm going to prescribe you an emotional support animal. What I caution everybody is there is no training necessary for an emotional support animal and no license or any kind of school that this animal has to go to. So I like to consider these kind of things when somebody comes into you and they said, here, look, my animal is classified as an emotional support animal. Here's the identification. Those are all red herrings, and they should kind of get your back up against the wall and say, wait a minute, something's wrong here, because if it truly is an emotional support animal, they don't need those gimmicks, as I'll call them. They don't need that documentation. What really drives this is two questions. One, you're looking to see, does the person seeking to use and live with this animal have a disability either a physical or a mental impairment that substantially limits one or more major life activity. And that's the definition that's used under the American with Disabilities Act. And the second prong is, does the person making the request have a disability-related need for that assistance animal? So the biggest part of this is there a nexus? First, you want to know, yes, they're disabled. Second, you want to know, what's the nexus? What's the purpose for that animal? For instance, if a person is diagnosed having a mental disability because they are suffering from PTSD, does that animal provide comfort so that that person, if there's additional noise or they're left alone, they won't either harm themselves or harm others because of their condition? So as long as the doctor can say, yes, it's under my care, I'm treating this person, and here's the nexus, usually that will pass the test. And then one of the things I caution is making sure that it is on a doctor's letterhead. It can be other, people ask me all the time, can it be a nurse practitioner? Can it be a social worker? And the answer is really, that's a gray area. What I like to see is I like to see the doctor's letterhead. And if I see that a doctor's letterhead has the specific doctor, but a nurse practitioner signing on his letterhead, I push back. I call that doctor and I say, your nurse practitioner signed this. However, I need you to be the person to sign it for them.
And can a landlord do that?
Yes.
Or is that an attorney's role?
So the rule is the doctor's note. If a person has a readily apparent disability, so they're in a wheelchair, they're blind, they're deaf, and you know that they have these disabilities. Either you can see them or you have knowledge. So if somebody comes to you and they say, I have PTSD when they move in, and they say, I'm telling you this because I have a caseworker who's working with me, and this is another person that I want on my record for you to be able to talk to, or if I can't pay my rent, go to them. If there's a readily apparent disability you're aware of, you can see, you can't ask for a doctor's note. The inquiry stops there. So at that point, you're not able to ask for additional information about the person's medical condition. However, where sometimes people are just depressed, they suffer from anxiety. These are things we might not know about, but they have real disabilities. In that situation, if somebody comes to you and asks for a reasonable accommodation, it's absolutely appropriate to say, I need a doctor's note. And so you can ask for the doctor's note. You can verify once you get the doctor's note that the doctor actually wrote it. So I would encourage everybody, push back always. Mm-hmm. I've had situations where I've seen the same doctor issue 2 different notes 6 months apart that were exactly the same. I questioned it, never heard from the doctor again.
So what does a landlord, what kind of recourse does a landlord have at that point? If, let's say the nurse practitioner did sign it and they call and say, we'd like the doctor to sign it, and then the doctor drops off. Because to be honest with you, we both know that the reasoning is because the doctor doesn't want to put his own skin on the line. He has no interest in, bending rules for somebody. If it's easy, sure. But if there's pushback, they're not going to. So what does the landlord do at that point?
So if you can't confirm that a doctor wrote the note, that's it. You can deny the accommodation. I would go a couple steps in between. What I would do is I would reach back out to the tenant directly and say, I've tried to confirm your doctor's note, so you keep them in the loop. Because tenants file for housing discrimination claims, 1, because they don't feel heard, or 2, they feel like they're not getting the answer they want.
Right.
So if you just disappear and you don't address their concern of why, chances are you're going to get a discrimination claim. So I would always reach back to the tenant and say, we've tried to reach out to your doctor. We can't get a hold of them. You might want to try and continue that so that we can try and accommodate you. We are fair housing compliant.
That's definitely one of the things one of the 2 rules in business that I have. First one is the right thing's always the right thing. The second one is document. If you're reaching out to the doctor, put a note on the application with the date and the time that you reached out, who you spoke to, what their response was, things like that. Right. You're basically building a file here. So when you either approve this application and you have this animal in the property, or if you deny the application and they try to fight you on it, you want to make sure that you have a firm grasp of everything that took place and what the denial reasons were, so that you have a defense, hopefully, when the time comes and
That's so true.
You're looking for that out.
Right.
I teach every one of my seminars with Jamie's A, B, C, D's, E's. Always be consistent and document everything. That's exactly what I start
love that.
with.
Yeah.
I love
And
that.
what you're exactly right. That's fine. I'll share. You are exactly right. It will become, if you standardize the form, and I have a proposed doctor's note, which I will share with anybody who's interested. But if you standardize the note, you standardize the forms you use and the responses you give consistently, it can be used as an affirmative defense to any complaint that you get or fair housing, either via HUD or via your actual state or federal laws. It can become that affirmative defense, because what you're doing is you're showing you're consistent in your approach to every tenant. And, if somebody comes in with a doctor's note, you get a response in situation A and it happens in situation B, the treatment's the same.
Love it. Yeah. I it's something that we preach all the time too. Document, consistency, all those things, because we've seen it firsthand too, where somebody's dealing with a discrimination lawsuit, and I've seen people effectively challenge them who genuinely didn't have any intention to discriminate. And now that they have all that documentation in place and are able to show this is what we do in every single situation, these testers that are out there trying to get landlords. I know it's a huge problem in California right now that we're hearing about. So landlords really, really need to be aware and vigilant in terms of
scripting yourself.
Yeah,
honestly,
right.
It's come to the point where you want to have an employee training manual that absolutely itemizes every single one of your policies. So your emotional support policy needs to be in writing, and the steps you take when you're getting an application in, when you're getting a request for a reasonable accommodation, you need to have that policy in place. So step by step, think about what you do when you're doing the actual vetting of that person and write it down. And then put it in a policy. And same thing with your criminal background checks, with your hoarders, all the same things. Once you start to do that, it really builds this manual for yourself.
Love it. And so break down a little bit for us what a landlord can do in the beginning. So in the lease stage, signing the lease, creating an addendum, something that can protect them in this situation specifically.
So while we all would love that a person disclose that they have the animal at the onset of a lease, that might not be the case. So in the situation where you're getting a new tenant in, it doesn't matter if you're talking about emotional support animals or if you're just talking about your average tenant who comes to rent from you. What I suggest, whether or not you're a no pet policy premise, or if you allow certain pets, whether it be one dog, one cat, or if you have size or weight restrictions, put everybody on what I call an animal responsibility addendum. Okay, I get out of using the term pet addendum about 6 months ago and made this change so that every single person signs on to this form at the onset of a lease. And in that form, it certifies whether or not you have an animal at the time you move in, even if you have a no pet policy. What it does then is it contains information in it, such as your rules and regulations for the animals being on the property. So the upkeep of the animal, the nuisance laws. So barking, if you have continuous barking for 30 minutes, whether or not it is in pet or if it's an emotional support animal, it's covered under this one addendum. Now, certain things will change for emotional support animals, such as the pet fee you're charging each month, or your pet deposit, or the fact that you may have to say that animal has to be curbed. But as long as you have a standardized form that's being used for your pet situations and for your emotional support animals that basically speak to the same terms for everything that can kind of cross over from one to the other, what you're doing is you're ensuring that there's no discrimination based on the ESAs. So it's a really good tool, and it will also lend, if you have a no pet policy and you have to make an accommodation, it gives you those breach of lease terms that you'd be missing otherwise if you don't have such an addendum in place at the start of your lease.
So a good example would be somebody has an emotional support animal, but the animal is barking like crazy, right? And so a lot of tenants are under this misconception that, well, it's an emotional support animal. It's untouchable. There's nothing you can do about it.
That's absolutely false.
Okay.
So that person doesn't clean up after their animal. That animal is urinating or defecating on site and not being cleaned up after. They're barking. They're showing aggressive behavior, whether or not it's lunging or growling or just showing its teeth, whether it goes and bites another tenant. or, tries to break the leash, all of those are subject to eviction, and they would be a breach of the lease. You want to make sure your lease then ties in that any breach of your animal responsibility addendum is a breach under your lease. But you basically have the same ability to get rid of the animal. Now, does not mean that you're going to be able to evict the tenant per se. What it does is it removes that very specific animal for the situation it's causing on the property. And usually tenants will come in and say, okay, if I can't have this animal, I want another. And again, you would have to go through a reasonable accommodation vetting, but at least it would get rid of the animal that's causing disturbances.
I got a question, Steve, as I sneak up on your shoulder. We actually we're recording this live on Facebook, and somebody asked a really good question. They said, can you have more than one emotional support animal at a time?
So the answer to that is yes, but it's complicated. So for each emotional support animal that is requested, it has to pass the vetting. So that means it has to have either this readily apparent standard. So somebody has to say, I need the emotional support animal because I'm in a wheelchair and that animal's going to fetch for me. And that provides comfort. Or it's going to be an animal that isn't readily, the disability is not readily apparent. And so you're going to be able to get the animal based on the doctor's note. So when they ask for an additional animal, again, you're going through that vetting stages because the second animal has to have a very separate purpose. It can't support the same disability's purpose that the initial doctor's note stated. So, example, the first situation, a person is in a wheelchair, and again, that animal is going to provide fetching ability, maybe being able to go get somebody's medicine and provide a lifeline in that situation. That animal may not be a dog, so it may not be able to be classified as a service animal because service animals under Title II and Title III of the American with Disabilities Act are limited to service dogs and in very specific circumstances, miniature horses.
So crazy.
Which should not pass muster in apartment buildings.
I've heard this before. Okay. Yeah, it's crazy.
So there's 4 carve-outs there. I'm not even going to get into it because realistically, no apartment building you're going to get a miniature horse pass through.
Right.
But so if it is classified as an emotional support animal and it's not a dog, it could be that it's a pig. A pig could be trained to go fetch medicine. Okay, so let's just go with that example. But then you get another doctor's note and you say, you know what, this person has become depressed because they're sitting in a wheelchair, they can't get outside, they can't see the fresh air, so we're prescribing a second emotional support animal for comfort because they are now depressed. Okay, so those are 2 different distinct reasons why you might need a second. As long as all of the information passes for a second animal, the answer is yes, you would have to make an accommodation to allow more than one or a different type of animal if requested.
Let me give you a little bit more realistic scenario probably, which is they have a pet.
Yes.
They have a second animal that they want to get classified, but that landlord of that property may have a 1 pet limit.
Yes.
Okay.
So again, you can't restrict on that ground. So even if you have a no pet policy, you have to allow the 1 in. If you have a 1 pet policy where you allow 1 per tenant, if somebody comes to you and says, well, this second one is an emotional support animal, you're not going to be able to deny it based on the fact that you only allow 1. You're going to need to make the accommodation for 2, unfortunately.
Wow. That's it's crazy. And I know that's what a lot of landlords that reach out to us are mentioning, even in the Facebook group. Right. They obviously are feeling at this point taken advantage of, right? I mean,
absolutely. So if you go back to what I was saying on these websites, if you look at emotionalpetsupport.com, if you were to look at the initial page, there's a picture of a woman on the first page and it says get started now, but above it, it's cut off on my page, but above it, it says, are you trying to get around your pet fee, monthly pet fee?
Oh, no.
Okay, so it's teaching you the tools of the trade. So people
gross.
are looking into this and they're saying, wow, I don't have to pay the monthly pet fee. This is fantastic. What do I do? Sign me up.
Yeah, exactly. Well, it's funny because the other site that you have there, I can't remember the name of it. I literally saw an ad for them on Facebook on the way here today.
It's funny. And usually, you gotta love that. It says, as seen on Vice on HBO.
Oh, great.
That should tell you something.
I love it.
But honestly, these are the kind of things, to caution some of the things I've seen. If you see these things and you see a doctor in California and the tenant is located in the state of New York, some people say, well, look at technology, look at the electronic ability. You know, you could FaceTime with a doctor, or you could technically have, you know, email back and forth where you give your concerns. The doctor's never actually seen you. And just by speaking to somebody, maybe they're willing to certify, but you know what? You still need a doctor's note that says they're a current patient. Not going to be one of these standardized letters from a company such as TheraPet or Emotional Pet Support.
Sure.
So that's a very real thing. I've seen some where the tenant lived in, you know, New York, and I'm getting a letter from China. I question those because how often are you going to be able to see? And again, there may be the one-off where, yes, they are a doctor, they were in New York, they moved to China. Who knows? You know, it could be, but then the doctor should be able to lay that out in a doctor's note for me.
Right.
So I always will test the envelope in that. And what I tell my clients is don't make that analysis by yourself. If you get one of these requests and it doesn't meet the criteria of showing this nexus, and a doctor's not willing to notarize the letter on their letterhead, give it to an attorney to look at. Let the attorney guide you and say, you know what, this doesn't pass muster. This is something I would push back on, or this is enough, and I wouldn't push this because you're going to end up with a discrimination claim.
So one of the questions, it looks like you might have a question here.
No, go ahead. Go ahead.
One of the questions I was going to ask, we talked a little bit about everything should be scripted, everything should be policy based. And if you sit and listen to when somebody calls in for a leasing call in our office, it's pretty much the exact same script every single time. What language can you and what language should you avoid using when talking to somebody who says, I have a pet, it's an emotional support animal? Say they tell you that right off the bat when they call to talk to you about the apartment. What can you tell them that they're going to need to provide to you so that they understand what the process is, and that it's not just going to be, oh yeah, you've got an emotional support animal, we'll just take that, no questions asked?
Sure. So again, you have to be careful because over the phone, you've never met that person. You don't know if there's a readily apparent disability you could see from them. So what you want to say is we are absolutely fair housing compliant. We follow all laws governed underneath the Fair Housing Act as well as the American with Disabilities Act, because the American with Disabilities Act will cover your common areas. So it'll cover your leasing office. It'll cover any communal areas such as your clubhouse, for instance. So you want to reference both those laws, and then you want to encourage the person to come in and apply. When you see them in person, then you can make the assessment whether or not they have a disability that you can physically see.
Right.
And if you can, your inquiry pretty much stops there. You're just going to say, okay, what's the animal, and get them signed up on your animal responsibility addendum.
Gotcha. Okay.
If you can't tell when they come in, then you can say, okay, here's our process. Our policy is that we, require a doctor's note that describes the nexus between what your disability is and what the animal is. And if you don't have a doctor's note, and here's where you get the little ability to guide them, you give a letter such as mine, which says, here's what I would like you to get filled out. And that becomes your standard form that you use for every tenant who doesn't have their own.
Yeah.
Sometimes they're going to come equipped with their own doctor's note, and you're not going to be able to say, well, this isn't on my note form. So you're going to have to take it and assess what their writing is. But, use that opportunity to guide them, get that letter filled out, and then you can decide whether or not to make the accommodation or not.
So basically over the phone, you
just say you're fair housing compliant, come in and apply.
Come in and apply.
Because the last thing you want to do is have that conversation over the phone, not knowing who's on the other end.
Right.
You just don't know. There's too many testers out there to know, and they're going to trip you up and try and.
Well, and it's funny, when we were coordinating the podcast here, I emailed Jamie and said, I just got 3 phone calls in like half an hour for people inquiring about emotional support animals. And this is after a couple weeks of there being a lot of discussion on the Facebook group and things like that about the same topic. I'm like, we have to do something about this because there's just so many questions. There's no answers. And it's, it's tester season. It really is, especially with it being summer, with students moving in and out of apartments. So we can tell. I mean, after you've spoken to a tester a time or two, you can pretty much always tell the style that they use. And it happens frequently that there are these testers out there. And they're not just targeting property managers. They're targeting small individual landlords just the same way. So it's, while you do have some exemptions as like a landlord, if it's an owner occupied, or if you have under a certain number of doors or whatever, just follow the laws.
Follow the laws because you
can never get in trouble.
You may have a duplex today, and then you may get an offer to buy multifamily down the road, and all of a sudden your portfolio went to 8 And then you're bound by it. Or you may say, well, I have a duplex, and that's not necessarily, on its own subject to fair housing, but you may also own 16 others that are held in the same limited liability company. And guess what? They're going to try and say, no, you own 16 properties.
Right.
You should be aware, even if they're all duplexes. So always good fair housing training is to comply. The other thing to know is these testers will go rogue on you. They will come to your property. They will actually not only do this over the phone, they'll either use email to do it and look for standardized responses. They will come to your property and they won't hit up the property manager who should know everything.
Right.
They'll hit up the construction worker who's doing your paving or your maintenance worker who's doing the maintenance on a property. And they'll start asking questions. And you need to train your staff how to handle those. Directing them back into the office is always the best answer. But I've had to do in fair housing training segments with just the maintenance staff because they are unaware of the limitations of what they should say.
Sure, absolutely. And it's funny now that you mentioned that, because I have more as a time savings thing than anything else. We have an email template that when a lead comes in, I make a phone call and then I follow up with the same email template every single time. And it says, what's your policy on pets? Yeah. And it's very straightforward. All of our buildings are no pets. So we clearly state we have a no cats or dogs policy. Caged and aquarium animals are considered on a case-by-case basis. Used to be, they're fine. Then we had somebody bring in a monster snake, and I'm like, all right, we need to we got to look at this a little bit more.
Have a disclosure in that sentence that says that you're fair housing compliant, though, and you would make reasonable accommodations?
I will as soon as I get back to the office.
So that's the game we're playing here.
Right, exactly.
You always want to put out that you are fair housing compliant, because if somebody takes a look at that, they're going to challenge. They're going to be like, oh, wow, that's somebody who potentially wouldn't make the accommodation because it doesn't say it. So always put in that clause that says that you're fair housing compliant and reasonable accommodation requests are, reviewed on a case-by-case basis.
And just, I know that we've talked about it before we jumped on the recording, that we're going to try to make some of the forms that we're talking about available.
Absolutely.
Which I think would be incredible. So anybody in the Facebook group or listening on the podcast will eventually be able to have access to those. Sure. And some of the forms that you've described, I've never seen them before. So I'm super excited. And I know same with Andrew, this is stuff that's changing now, that's happening now.
And it's consistent. So I may do somebody's lease and 6 months later, it's a necessity to call them back up and say, you know what, we put this in there, this HUD guidance came down, or this statute changed, or this case came down, and now you got to change it again. It's an ongoing process. And so part of the lease process is to leave open in your lease that on 30 days notice, you can change any part of a lease that a tenant is used to. So, and this is all evolving. Obviously, this is in the tenant's favor if you have something like that in there. So, you want to keep current. It's one of those things that, I suggest everybody sign on to the HUD site and keep track of the guidance as it rolls out. I certainly can start giving you guys heads up that this is what's coming down. Yeah. And it's in the Obama administration, we had a lot of HUD guidance. It's less so since the Trump administration, but you never know, things can change.
I agree. Same in our industry is the exact same. So this is a question relating to landlords and their propensity to not want to get an attorney.
Yes.
So I live in this world.
We're evil.
Yeah, right. So owning a business, I have an attorney on retainer. It is not an unusual thing for me. It's just common knowledge. And I know a lot of landlords have this pushback about finding an attorney, having a relationship with an attorney. Maybe you don't have to have one on retainer, but at least having that relationship. How important is that for landlords these days?
So I will say this. So all of my clients know that on a minute's notice, they can email me and I will respond. I do not charge them. I think that's the biggest thing to warm people up to you, is that you need to be accessible. You need to give, a minute of your time to answer an email, field a phone call, take a call that says, you know what, I want to come out and speak at these kind of things. Those are all things that they really form a relationship with a client. And my motto on all of this is, you know what, if I give away 10 minutes of free advice, the time that they get sued, they'll turn to me as their attorney and actually hire me. And I'm going to get paid if needed because I know what I'm talking about, and they can trust that. So I think it's building a relationship. It's knowing when to reach out. If you're unsure, reach out, because the worst thing that could happen is that you make a wrong turn on one of these. Just to give a basis, and this is every state, if you get one of these claims that somebody files against you, either in HUD or in New York State for the New York State Division of Human Rights, you're looking at a $10,000 easy retainer to have an attorney just get into it, whether it's with the administrative judge or with a law clerk, to say, here are the facts. My client didn't do anything wrong. $10,000. Mm-hmm. That's assuming there's no discriminatory intent that occurred. If they could prove there's discriminatory intent, or these two different areas, either the courts or HUD, find that, maybe there was some discriminatory intent behind it based on your past history or based on the fact that you don't have documentation to show what you do in every instance, you're looking easy $50,000 to defend one of these. So the 10 minutes it takes to ask the question, even if your counsel in your local area is going to charge you $100, save yourself the $100.
I couldn't agree more. So do you have a specific type of attorney that they should look to? Should it be a real estate specific attorney?
So most of the real estate attorneys that I have either run into, worked with, or worked across the table are closing attorneys. So they specialize in residential or commercial lending or buy-sell agreements. I think it's very rare that you find somebody who represents property management groups and who has fair housing as their niche. Mm-hmm. I say that because the only landlord association in the state of New York is located in Albany, and I am their go-to attorney because they couldn't find anyone else who had this knowledge. So the New York Capital Region Landlord Association is who I consult with and back and forth. Same thing with local groups who are doing this. There's not many of us out there. So I would look for somebody who's fair housing trainer, and make sure that they are an attorney, because there's also these companies out there that will do fair housing training, but they're not giving you real legal advice for doing it. They're giving you materials, but they're not with the law behind it. So if you can find somebody in your local area, fine. If not, I welcome anybody to reach out to me, because it is a federal law. I can certainly give you guidance on that, and if necessary, help you find a local attorney to get the state specific side for you.
You just may have acquired about 3,500 new clients in the Facebook group.
It's okay. I might be a fan favorite of my law firm.
Well, we will definitely post your information and how to get in touch with you and how to contact you. And so far, I'm blown away the amount of information. We've had attorneys on the show before that it's like it kills you to try to get information because they want to play it safe. They don't want to give an answer that may not be the right answer. But you clearly know your stuff, and you've given us some amazing answers here. And so I want to give an opportunity, if you're willing, to answer some of our Facebook group questions.
Absolutely.
So I see that you took a couple of notes. So I don't want to throw you one that you haven't already taken a look at. So let me see what you got there. You got...
Let's go for Laura's question about the pit bulls with the insurance company, because I think that's something everybody wants to know. So I'm going to give you really quick a list of assistance animal pitfalls. And Laura, I hope this answers your question. Basically, restricting breed, restricting size or weight, requiring a pet deposit, charging a monthly pet fee, requiring tenants with emotional support animals to sign a pet or an animal addendum that contains conditions or restrictions not applicable to emotional support animals, such as requiring them to be in a crate, limiting residents to only only emotional support animals. All of those are pitfalls that you will fall into. So let's get back to her question specifically. If the animal that's being presented as an emotional support animal is a pit bull, or likewise a Rottweiler, an Akita, a German Shepherd, anything that most of us have as our restricted breeds is presented, and they want this animal, and you're giving them the answer that your insurance company will cancel or won't allow it, that is misguided. Because there is a regulation that HUD has that says that the Department of Justice wants to know if your insurance carrier changes, modifies, or wants to cancel your insurance based on the fact that you're allowing one of these restricted animals into the residence. They will actually hold the insurance carrier liable, because you are going to have to comply with fair housing. So will they. So I have a real life story with that. One of my great clients was floored and said, my insurance carrier won't do it. And I said, well, that's against the law. You can't do that. You still have to make the accommodation. We pushed back against that insured, and they changed their policy. just as of 2 weeks ago. So it's education. Some of these insurance carriers are just not up to speed on what the requirements are. And that's something I will make available, the HUD regulations showing that from the insurance carrier perspective, because I think a lot of people would like that in their back pocket to say, okay, I have to make the accommodation and now I need to tell my insurance carrier they need to as well.
Yeah. And I think super important for any landlord listening, because that's something that has obviously been changing or it's been evolving. And I know a lot of landlords, that's their go-to. That's their go-to. We can't do it because of this, or it's a restricted breed. So landlords, don't do that anymore.
Yeah, don't use that as a reason.
Right. All right. What else we got?
Okay, so Dennis asks, at what point should the prospective tenant bring up the issue of the emotional support animal? And can you charge an extra deposit or higher rent? And do ESAs include cats, snakes, or what other pets? So emotional support animals can basically consist of any animal. There's no defined limitation on them. However, I will caution that the rule is that you can deny the animal if the animal presents either a undue hardship or a burden for administrative purposes. So the undue hardship part of that will cover things such as your health code violations or just your regular city code or town code that will prevent things such as exotic animals. So I have seen people make requests for monkeys, for tigers, for elephants, and I'm not kidding, snakes, tarantulas, pigs. So if you can look to your town code, your local code, and you could say exotic animals, for instance, are outlawed and you can't do that, you can deny it based on the fact that you can't comply with that request. Again, that doesn't mean you can deny any animal. You just have to say that specific animal doesn't meet licensing requirements in this town. One of the things you always should ask for is veterinary records, because you want to make sure that they are up to date with things such as rabies shots, because again, they're living amongst other tenants. They need to comply with that still. One of the other things to always ask is whether or not the animal has ever bit anyone. And the reason in New York State, for instance, is a landlord who is put on notice that an animal has a vicious propensity to bite or has bit someone in the past. If that animal should bite again, the burden of liability shifts from the tenant to the landlord, and the landlord would be liable for that bite. Wow. So you need to ask that question.
Is an animal bite a reason to deny an ESA?
It absolutely could be. I mean, it's one of those things that you want to look back. How far ago did it do it? You know, did it do it when it was a puppy and now the animal's 13 and it's not had any other issues since? Case by case basis, but yes, it could potentially
that's so
be
sticky.
used.
It really is.
It always, and these are the questions. Let your attorney vet,
right?
Because then at least you could say, my attorney told me, and it's not guessing to your boss.
Yeah,
right. All right. I know one of the questions that we had, I'm not sure if this is one that you prepared an answer for, but was about, Etta asked about, what if another tenant in the building has an allergy?
Yes.
Okay, so I know that's something that you have some experience with too.
So again, unfortunately, because you have to make this reasonable accommodation, if they fulfill the obligations under the HUD guidance, the person with the allergy, while you want to safeguard them because they're probably a good tenant, paying on time, doing all the things they should do, and while I know people say it's not fair, unfortunately, you still need to make the reasonable accommodation. From a public relations standpoint, best practice would tend to be try and see if you can accommodate both. Ask the person with the allergy if they would be willing to relocate to another potential premise within your complex. If you just can't, then one of the things to do would be allow the tenant to break their lease without penalty. That's always something. And while you lose profit, you lose a good tenant. Again, it's a cost analysis between doing that to the good tenant who unfortunately now you can't accommodate and the one that brings a discrimination claim for $10,000 to start.
And that situation sort of encapsulates the frustration of landlords, right?
Yeah.
Absolutely.
Now you've got this tenant you have no loyalties to whatsoever other than you're trying to follow the laws.
Right.
But you may have a tenant that's been there for years and now you're letting them go.
The only thing to say is in a bigger complex, there's nothing to say you're guaranteeing a very specific unit for the person who's coming in with the emotional support animal. So if you can manipulate that, we have this person who has an allergy. I can't place you around them for, for their health reasons. We have this other apartment that you can go to, if it's the same exact unit, first floor, 2-bedroom, you can move the person with emotional support animal over. And because they're asking for a reasonable accommodation, they should also understand the person who has a current, allergy situation going on. You would hope.
You would hope. I don't know if that's always the case.
Right.
All right. So, do you want to go over Sarah's there at the bottom, I think?
Sure. Sarah asks, if you are pre-screening a tenant and you ask about any pets or who will be living there and they make no mention of said support pet, is it considered withholding information if they fill out an application and tell you about the support pet?
Can we fix her nomenclature first? It's
Yes.
not support
Animal.
pet. It's not support pet ever.
Animal.
Right.
Animal.
Right.
And in fact, I would get away from calling any pet a pet.
Okay.
I would start getting into this animal term.
Gotcha.
To cover all bases under the lease. But so if you're pre-screening a tenant and you're asking about animals and you were to have this animal responsibility addendum as part of your screening process, part of your lease process, you wouldn't get into this situation because they would either mark yes or no. And then what you would want is you want a corresponding default provision in your lease that says any misrepresentation or omission in your application is a default under the terms of the lease. However, I caution you here in the realm of emotional support animals, while they might not have one when they move in, under the HUD guidance that came out in 2013, it specifically states that you can't deny that because they didn't give it to you when they moved in. It could be that 6 months down the line, you find they have an animal. You question them as to my animal responsibility addendum says you don't have one. Mm-hmm. And then they say to you, oh, it's an emotional support animal. At that point, you still need to go through the vetting process at that moment to see if the animal supports it. Now, if they're telling you 6 months ago that this animal was an emotional support animal, they just didn't tell you. Mm-hmm. So you want to make sure that doctor's note justifies 6 months prior that they were being seen. Right. And 6 months prior, it was an emotional support animal. You will trap people in that who are working the system.
That makes a lot of sense, actually. And I don't know how accurate this is, but I've heard that once an animal, emotional support animals and service animals are two kind of different beasts, I guess. I've heard that once it's like an actual service animal, like a properly trained service animal, say a seeing eye dog or something like that, it's not an animal anymore. The terminology changes to, I think it was like medical assistance device or something like that. It's not even, they don't even view it as an animal. They just view it no different than somebody who needs oxygen for COPD or something along those lines.
So quickly, we'll go over this really quick. So the term assistance animal is actually all encompassing. It covers service animals, therapy animals, and emotional assistance animals. Okay, so all of those cover one. Service animals, again, are very specifically constrained to guide dogs or seeing eye dogs. That's it. Hearing or signal dogs are the same thing. They're going to be wearing very specific gear that identifies them as a service animal. So people shouldn't question. They're also very specifically trained. From the time that they are puppies, they are specifically assigned to this person or this type of disability. And so they're trained right away up until the point where usually they're full grown or a year. And then they're assigned out to somebody for very specific purposes. So they will have specific training. They will have certifications. There should be no question. Those are very easy to say, okay, this meets that. Where emotional support animals, there's no training. There's no licensing requirement, and it could really be haphazard in what kind of animal it is. So that's where you start to get into people using the system to get what they want. You know, if people are saying, oh, they're trained to be an emotional support animal, they're using terms that don't go with it. So listen to what people are saying. If they start saying, oh, they're trained, they're certified, I have paperwork, wrong. I don't know how we're doing on time. I will give you a very real scenario of somebody who did need an emotional support animal. I represented a gentleman. I wrote an article for the Daily Record in Rochester last year. And this guy Googled somebody who knew what they were talking about under the emotional support animal. And he said I was the only one he could find who knew what they were talking about, which may or may not be true. I represented him in New York City, and it turned out that he had a diagnosed mental illness, 5 years worth of information to support the illness. And his landlord just wouldn't make the accommodation for an animal. Mm-hmm. He worked on Wall Street, 9 to 5, was able to work on his own, no distress. However, his wife lived outside of the city, so Monday through Friday he didn't see her, so he came home to an empty apartment. When he came home, he was a shell of himself. Couldn't function, couldn't cook for himself, couldn't watch TV, couldn't relax, had lots of anxiety. The animal provided support. We challenged it, and the landlord lost that one. It got settled out of court, but in that situation, I could provide 5 years of documented medical diagnosis of, the situation he was in, and that he was fine when he was with his wife. He was not fine when he was alone. He was fine when he was at work. And what started happening, why this became such a big deal, was this anxiety overtook him, and then he just started falling off at work. He was tired. He was not able to eat anymore. He lost weight. So if you can legitimately show, I don't want to discourage people that this is all a gimmick. There are genuinely people out there who need these animals, and it's a shame what people are doing to, muddy the waters for those people.
I've got friends that I served with in the Marines that have genuine cases of PTSD, and the animals are an amazing companion for them.
It makes them be able to live amongst people, and that's the truth.
Yeah, I think it's important to make that clarity. This is, and a lot of landlords, we can fall into that trap of just thinking they're all bad. They're all bad. They're not.
They're not. And that's why I tell that story a lot, because I don't want people to get in the mindset of they're going to approach this as it's a gimmick. Yeah. While many there are the one-offs who genuinely need this. And so they won't be coming to you, and they won't be saying it's certified, or it's, here's my license, here's the picture, here's the shirt.
That's the shirt.
All those, use as tools of your trade once you get used to this to say, red flag.
Right. Well, Jamie, I got to say, I'm blown away by the amount of information.
I'm glad it was helpful.
The clarity of it, which is super rare for the attorneys that we've had on in the past. What a difference. Amazing. We absolutely will have you come back in and would love to do anything with you again. And I know that we're going to have some resources on the Facebook group, the website, the podcast show notes, wherever we can put them. We want people to be able to get a hold of the information that you have, the forms, how to get in touch with you. Great. So what a great resource. You truly are a champion for landlords and a hero.
Absolutely.
For real. I mean, honestly, I think this is the clearest we've ever had as far as clear-cut answers and what you can and cannot do.
Yes, there's very rare. I will not usually represent tenants. That guy in New York City was outside my practice area for the most part, which is why I took it on. But we'll usually say no because we represent so many landlords that it's really a craft service geared towards landlord-favored items.
Right. All right. Well, that does it for the show. Thank you again, Jamie.
You're welcome. Thank you for having me.
Thank you, Andrew, for being on. Thank you, Eric, for creepily sneaking up behind me, and for, of course, recording the whole thing. Everybody, we appreciate it. Anybody that has any questions for us, reach out on Facebook Live, and of course, check out the podcast RentPrep for Landlords. Thanks, everybody.